Good morning, everyone, and welcome to Archer's webinar this morning. This morning we are going to be covering the construction questions that you dare not ask. So just before we get going, I thought I'd introduce those who are involved in the webinar today. So for any of you who don't know me, my name is Ruth Sunaway. I'm a partner at Archer, specialising in construction disputes. Having been at a large regional firm for a number of years prior to setting up Archer on the 1st of June last year. I'm delighted to be joined today by Hanna McNab, who is a partner also, and also my colleague Hayley Morgan, who is a solicitor at the firm and who joined us on the 1st of January this year. So just before we get started, you may see on the right-hand side, you've got a public chat and a presenter chat, or we've got a presenter chat box, you've got a public chat box. You are more than welcome to put some questions in there and we will endeavour to get through those at the end of today's webinar. And we have also had some questions in advance, so we will try and get through those too. For anyone who doesn't want to see big pictures of our faces, someone tells me that if you log into this on your phone, you get to see the slides with little pictures of our faces. So hopefully the IT will work for that. But without further ado, I will just move on to the questions today that we're going to be asking. So we're going to be dealing with fitness for purpose. We're going to be dealing with indemnity clauses. We're going to be dealing with ownership of materials on site. We get asked a lot of questions about that in our role, especially in relation to insolvency. We get asked about big time and being at large and extensions of time. Liquidated damages. We asked a lot of questions about PI, consequential losses, limitation periods, net contribution clauses, and loss and expense claims. So without further ado, I will pass you over to my colleague, Hanna.
Good morning, everyone. I'm Hanna McNab. I'm a partner here at Archer. And the first topic I want to discuss with you is fitness for purpose against duty of care. So starting off, it's really important to be clear about the standards that apply for each part of construction works. The test for workmanship is whether the work has been carried out in a good and workmanlike manner. The test for the quality of materials is whether they are fit for purpose. And the test for design is whether the design has been carried out using reasonable skill and care. However, it is vital that the skill and care referred to for design is the reasonable skill and care of a designer. Now, we need to go back to 1980 to explain why this is and look at the case of IBA and EMI and BICC. So these proceedings related to the construction of a TV mast on Emily Moor. As a result of high winds and ice, something called vortex shredding occurred, which resulted in the mast collapsing. At the time, the contractor, EMI, had appointed BICC to carry out the design. However, there was no express reference to the nature of the duty of care for EMI towards IBA, who was the employer. Now, in this case, the court distinguished between a contractor's level of skill and care as opposed to that of a designer. The court effectively said that in the absence of any contrary wording, a contractor guarantees that the finished product is fit for purpose, and this includes the obligation for design. So in practice, what has emerged is a bizarre situation where the contractor's duty of care for design is higher than that of a designer. This is why it is important that any reference to the standard of care for design is to that of a designer and not a contractor. For example, both NEC and JCT in the standard form contracts refer to reasonable skill and care to be expected of a designer, even though these are contracts for contractors. This effectively removes the issue created by IBA and EMI. So as well as the IBA case, there is the relatively recent case of MT Hogard. Now, this claim related to the Robin Rig wind farm, which was a large wind farm in the Solway Firth. Now, unfortunately, the grouting to the foundations failed. It was accepted that the design carried out at the time was to recognised standards, just that the standards were not correct, and the cost of repair was some £23.6 million. Now, in simple terms, there were conflicting clauses in the contract between the parties. One clause said that the contractor was to use reasonable skill and care. However, there was also one provision tucked away in a specification saying that the foundations would have a design life of 20 years. Now, this clause was being seen as a fitness for purpose obligation. The exact words in the specification were, the design of the foundations shall ensure a lifetime of 20 years in every aspect without planned replacement. The court therefore had to decide what happens where there are conflicting terms. They came to the conclusion that the higher standard applies, and Hogard was ordered to pay £23.6 million. So why does it matter? Well, put simply, if you sign up to a fitness for purpose clause for design, it is very likely that you will not be covered for this on your insurance. If you look at this extract from an insurance policy that I've added to the slide, the exclusions refer to you not being protected for a fitness for purpose obligation. Now, insurers being insurers will argue that this means you are uninsured full stop and not just only up to the level of reasonable skill and care. So to make sure you don't fall foul of being outside your insurance policy, you need to check that any reference to using reasonable skill and care for design is that of a designer and not of a contractor. Be very wary of terms saying that works will be fit for purpose. At best, this should be limited to materials only. Look out for performance wording that says it will comply with the performance specification. If you have this wording, make sure you read every page of the specification closely to avoid the Hogard situation. Also, beware of collateral warranties having different levels of skill and care to the main contract or appointment. Check your warranties carefully and make sure they match the underlying document. So some clients we work with now add the following wording on the slide or something similar to each contract to avoid falling foul of the Hogard issue. The wording expressly states that the contractor's liability for design shall not extend to one for fitness for purpose. This may be something you wish to consider putting in your contracts going forward. And of course, we can assist with the drafting of any such clause. So moving next to indemnity clauses. What is an indemnity? Well, the word indemnify means to recompense for a loss or liability. There are effectively three types of indemnity: a debt or no breach indemnity, an insured indemnity, or a contractual indemnity. Now, you won't necessarily find these three definitions in the legal textbooks, but this is probably the easiest way to explain them. So looking first at a debt indemnity. If the indemnity is construed as a debt indemnity, there is no obligation on the indemnified party to mitigate its loss. It is just a direct payment for the agreed sum, end of. In the context of construction contracts, these are relatively rare. The second type of indemnity are those that are effectively indemnities to reflect insurance. Insurance policies are policies of indemnity. So if a party gives an indemnity which is covered by its insurance, there should not be an issue. So looking at the standard JCT wording on the slide as an example, this clause is an indemnity given by the contractor for any property damage caused by its actions. This clause does not relate to the actual property being worked on. So in effect, it is covering damage to third-party property. This is what a standard public liability or third-party liability policy covers. So this indemnity is backed off against the third-party liability policy. Now, the third type of indemnity, and the far more common type, are contractual indemnities. Typically, you will see wording that says the subcontractor shall indemnify the main contractor for any breach of the main contract by the subcontractor or something similar. On the slide, I've put a couple of examples of contractual indemnities so you can read them. There is a perceived risk that by giving an indemnity, a party is just offering a blank cheque. However, that's not quite right. It depends on the wording of the clause in question, but as a general rule, the courts will still require the indemnified party to mitigate its loss. The indemnity will also only cover direct losses, and there has to be a breach. It is not just a given that the sum stated by the indemnified party is required to be paid. Now, whilst it does depend on the wording of the clause itself, the general, oh my God, it's an indemnity, we cannot agree to this, is actually a misunderstanding of what a contractual indemnity is. So, just some things to do, and in the absence of any express wording, the position for an indemnity is not a great deal different to that of a normal breach of contract. So if you're the party being indemnified, you want to make clear that the indemnity covers all losses, direct, indirect, and consequential, that the clause uses the word indemnity to make it clear that is what it is, and that there is no requirement for you to mitigate your loss. You also want to make sure there's no cap on liability. Conversely, if you are the party that is giving the indemnity, you'll be looking to limit the scope of any liability. To do so, you'll need to ensure that the indemnity covers direct loss only, that the indemnified party is under a duty to mitigate its losses, and that there is a cap on liability. As with all contractual clauses, indemnity clauses should be carefully drafted so it is clear exactly what is being covered. So the third topic I want to talk about relates to materials on site. Now, there are two basic principles concerning materials on site. The first principle concerns whether the materials are fixed to the land. The second relates to the legal position regarding title to materials, which is quite complicated. So the main scenario where this issue arises is the insolvency of one of the parties in the chain. Typically, the scenario is a contractor and or subcontractor goes into insolvency, and the question arises as to who owns those materials left on site. Now, the position with offsite materials and vesting certificates is clearer, as the parties are expressly dealing with the position regarding materials in those documents. The area where there is most confusion is the day-to-day materials that remain on site after insolvency. So the starting point is simple. If the material is fixed to the land, then that is that. Title passes to the owner of the land once the material has been fixed. The legal expression quid plantor solo credit effectively means that something is fixed to the land is deemed to be the property of the owner of that land. I'm sure it will come as no surprise that there is often a certain amount of disagreement as to what is fixed to the land. Bricks in a wall are fixed, but is something bolted down fixed? Is a heavy piece of plant fixed? There will always be discussions on this, but if the material is fixed to the land, it belongs to the owner of that land. Moving now to the position whereby the materials are unfixed. So the first key question is whether the underlying contract is a supply-only contract or a supply and fixed contract. Basically, the difference between a pure supplier and a subcontractor. If it is a supply-only contract, then the Sale of Goods 1979 comes into the aid of the employer. Now, I've put the wording of Section 25(1) of the Sale of Goods Act up on the slide. This means that an employer who takes possession of materials takes good title if it didn't have notice of any retention of title clause relating to the materials. So what does that mean in practice? Well, the typical scenario is when a contractor enters into insolvency. The employer has paid the contractor for the materials, but the contractor has not paid its supplier. The supplier has a retention of title clause in its terms, saying the title does not pass until it has been paid. So under the supply contract, the supplier owns the materials, but under the main contract, the employer has paid for the materials. So who owns the materials? Well, the Sale of Goods Act basically says it is the employer who owns the materials. The employer has possession of the materials, and the retention of title clause was not in its contract with the contractor. So in legal terms, it did not have notice of the retention of title clause in the contract between the contractor and the supplier. So it seems pretty unfair on the supplier to me, but this is the legal position with a supply-only contract. Now, supply-only contracts are relatively straightforward, but what about supply and install contracts, i.e. a traditional subcontract? Firstly, these are governed by different legislation, being the Sale of Goods and Services Act 1982. The key point is that there is not an equivalent provision in the Sale of Goods and Services Act compared to the Sale of Goods Act. So we've got another legal expression, nemo dat quod non habet, which applies to supply and install contracts, which basically means one cannot transfer to another more than it has. So even if the contract states that title passes to the employer if the employer pays the contractor for the materials, if the contractor does not have title to those materials because he's not paid the subcontractor for them, then title does not pass to the employer. The employer cannot get title in materials if the contractor does not own that title. So the best way to explain this is to look at a question. I've put the question up on the slide. So a subcontractor enters into a subcontract with a contractor in relation to some works on a large residential property. The subcontractor is a supplier of extremely expensive handcrafted ornate metal staircases. Following previous bad experiences, the subcontractor always inserts a retention of title clause in its subcontract. The subcontractor has installed the staircases when the contractor enters into insolvency. At this point in time, the contractor has not paid the subcontractor for the materials and/or installation costs, but the contractor himself has been paid by the employer for those materials. The staircases can be unbolted from their permanent positions relatively easily. So question 1, does the subcontractor retain title to the goods, and as such, can he go and retrieve the staircases? Now the answer to this is most likely going to be no. The staircases are probably seen as fixed, as they are in their permanent position with the permanent fixings, despite the fact they can be removed relatively easily. This means the employer has title to the staircases. So, next question, same scenario, but would the answer be different if the employer had not paid the contractor for the staircases? Now, the answer to this is actually quite straightforward. It is no, the answer wouldn't be different. This is because the staircases are probably fixed. As the staircases are fixed, they are owned by the owner of the land, being the employer. It is not a question of payment in circumstances where material is fixed to the land. It is whether the materials are fixed or not. If the materials are fixed, then they are owned by the employer. Now, to question 3. Would the answer be different if the staircases were not fixed and the employer had paid the contractor for the staircases, but the contractor had not paid the subcontractor? Now, the answer to this is yes, the answer would be different if the staircases were not fixed. The fact that the employer has paid for them does not assist, as he cannot be given more than the contractor has. The contractor will almost certainly not have obtained title to the staircases, as he's not paid the subcontractor for those materials. So in this instance, ownership is still in the hands of the subcontractor. What happens if the employer does not give the staircases back to the subcontractor? Well, this is where the tort of conversion comes in. It also relates to the legal issue of bailment, which I'm not going to go into now, but to simplify the position for the purpose of this talk, if a party keeps goods owned by others, it effectively has to pay for them. Therefore, if the employer wishes to keep the staircases, he needs to make payment to the subcontractor for them. So the next area I want to discuss is time at large. You will often hear people say that time is at large, but really, what does that mean? Now, in simple terms, it means there is no date fixed for completing the building works, or the times previously agreed for completion no longer apply. In the very unlikely event that time is at large, what the law says is that the works need to be completed in a reasonable time. There is no right to deduct liquidated damages. However, there is a right to fall back on general damages. So the only reason time is at large is if there is no date fixed for completing the works. In practice, this occurs when there is no right to be given an extension of time for employer acts. So, for example, if you had a GMP contract with no right for an extension of time at all, even for employer prevention, that would be an example of time being at large. However, each of NEC, JCT and other standard forms of contract all have a right for the contractor to be given an EOT for employer delay, so time is not at large in those circumstances. Now, this was reinforced in the 2007 case of Multiplex and Honeywell. I'm just going to read out what Mr. Justice Jackson said in this case. He said, the construction point turns upon the operation of the prevention principle in the context of the present subcontract. The essence of the prevention principle is that the promisee cannot insist on the performance of an obligation which he has prevented the promisor from performing. In the field of construction law, One consequence of the prevention principle is that the employer cannot hold the contractor to a specified completion date if the employer has, by act or omission, prevented the contractor from completing by that date. Instead, time becomes at large and the obligation to complete by the specified date is replaced by an implied obligation to complete within a reasonable time. The same principle applies as between main contractor and subcontractor. It is in order to avoid the operation of the prevention principle that many construction contracts and subcontracts include provisions for extension of time. Thus, it can be seen that extension of time clauses exist for the protection of both parties to a construction contract or subcontract. So this slide just reinforces the point. The scenarios on the slide do not make time at large. They just make it very difficult to work out what the EOT actually is. Very rarely will time actually be at large. So the next topic I'm going to discuss is a contractor's entitlement to an extension of time because of a delay caused by a statutory undertaker. Interestingly, the British Property Federation has stated that this is the most common delay on construction projects, so it's important to get this right. Now I'm going to look at when clause 226(7) or its equivalent in other JCT contracts applies and how the case law has made clear what the position is. However, just a warning, it is not what you think it is and it is not how most people operate this provision. Ultimately, the question boils down to, does a contractor get an EOT if a statutory undertaker causes delay? So there are firstly some questions that you need to ask. First, is the party actually a statutory undertaker? With the deregulation of the utilities industries, is the party causing the delay a statutory undertaker under the contract? Second, who was the party who contracted with the statutory undertaker? Was it the employer or the contractor? And third, what is the work the statutory undertaker is carrying out? Is it pursuant to a contract or simply by virtue of its statutory powers, for example, under the Water Industry Act or the Electricity Act? So what does the case law say? Now, there have only really been two cases on this, and the main case is Henry Boot in Central Lancashire from way back in 1980. Now, Henry Boot were constructing a housing estate for the Central Lancashire Newtown Development Corporation. The actual detail is scant on the case, but the judge's decision is very clear. Where a statutory undertaker was carrying out work pursuant to a contract, it was not covered by clause 226(7) or the equivalent. This is because the work being carried out was not in pursuance of its statutory obligations. So the best way to look at it is if EDF or UKPN or Anglian Water has a statutory right to come onto the land and do work required by virtue of their statutory powers. Any work they do under a contract, which in practice is 99% of the work they do carried out, is pursuant to the contract and not its statutory obligations. So the right to an extension of time under 226(7) is actually very limited. What the judge in the case basically said, it simply boils down to who is responsible for carrying out the works, employer or contractor. Whichever party it is, takes the risk for any delay by a statutory undertaker. Now, there is a slightly more recent case, which is Jerem Fulkus and Fennis Investments, and that considered the position following the deregulation of utilities industries. And does the party amount to an employer's person or a statutory undertaker? Now, the court made clear in its opinion that a party performing a function which is equivalent to a statutory undertaker should be seen as a statutory undertaker. What this effectively means is that Henry Boot remains good law. So to the question, does a contractor get an EOT for a statutory undertaker delay? So the first point to note is a typical position, is the contract with the contractor. Most typically, the employer has a provisional sum for this work and the contractor is expected to enter into the contract with the statutory undertaker. The supplier, whether it is an actual statutory body such as EDF or a newer equivalent such as GTC, makes no difference. They are both seen as statutory undertakers following Jerem Fulkus and Fennis. Whilst the position gets confused slightly with the contract for the meters being with the employer, as the stats will always insist on this isn't normally the delaying issue. In practice, if the contractor employs the statutory undertaker, it takes the risk for the delay, so will not be given an extension of time. Now, the final topic I want to discuss before passing over to Hayley is how to deduct liquidated damages. So, starting off with some basics. You cannot deduct liquidated damages until the original completion date has expired. Even if the contractor is running months late, until the original completion date has passed, no deduction can be made for delay. Also, if there is an EOT granted to the completion date, this is amended. The practical issue of deducting liquidated damages is that you do not want to wait too long before deducting the money from the contractor, such that the total sum you want to claim is more than the sum due to the contractor. Ideally, as employer, you want to be deducting liquidated damages from sums otherwise due and not trying to recover it back as an overpayment. This involves an assessment of the sums left to be paid against the amount of liquidated damages payable. If you are a consultant, your client is not going to thank you if you get to the point where what is left to pay is less than the amount of LDs being deducted. Now, people often worry about the reaction of the contractor. Whilst this is not without some merit, it should not be forgotten that the contractor will simply deduct similar sums from those subcontractors it considers are responsible for any delay. The leading case on how to deduct liquidated damages is Grove Developments and S&T. Now, while the dispute mainly concerns smash and grab adjudications, there was a secondary issue that the court had to consider, and that related to what was needed to deduct liquidated damages. The form of contract was a JCT Design and Build 2011. The court decided that the contract required 2 notices to be issued under clause 229 of the contract, a warning notice and a deduction notice. The fact that these 2 notices were issued just 7 seconds apart was irrelevant. What was key was that the notices were issued and that they were issued in the correct order. So what notices actually need to be issued and in what order? Firstly, the employer's agent or contract administrator needs to issue the notice of non-completion. Despite what some people think, this does not need to be issued the day after the original or revised completion date. In fact, it can be issued at any time up to the final statement. The main point to remember, though, is that you cannot deduct liquidated damages until this notice and the other notices have been issued. Also, an important point to note is that if an EOT is awarded, the notice of non-completion must be reissued. Many a party has failed to reissue a notice of non-completion following an EOT and then found themselves unable to deduct liquidated damages. Now, the JCT wording for what notices come next is not particularly clear, and until Grove and S&T, most people thought there was a requirement to issue just 1 notice confirming that the employer may withhold or deduct damages. However, as I said earlier, Grove and S&T confirmed you need to issue 2 notices under clause 229. Now, the first notice arises under clause 229(1)(2). This is the employer effectively saying it may withhold or deduct liquidated damages. Following Grove and S&T, this has been labelled as the warning notice. The second notice arises under clause 229(2). This is the employer stating what level of liquidated damages will be applied, either the full rate or the lesser rate. This is known as the deduction notice. Finally, the fourth notice is required to be issued, which is a pay less notice. You have to issue all 4 notices to be able to deduct LDs. 3 of the 4 will not do. I've set out on the slide the order in which the notices need to be issued. Remember, a non-completion notice needs to be reissued if an extension of time has been granted. You do not need to issue notices 2 and 3 more than once, but you do need to make sure both of them have been issued and in the correct order. And finally, you need to issue a pay less notice to complete the set, and this must be issued against each application for payment. So that's me done for now. I'll hand you over to Hayley, who is going to start with a discussion on the types of professional indemnity insurance.
Thank you, Hannah. There are 5 concepts that I'm going to explain today, and the first of which is the types of professional indemnity insurance available. Now, it's important to note that professional indemnity insurance assures against all liability arising from professional negligence. In construction, this can arise from negligent design, services, or specification. It's required from a design contractor, any design subcontractors, and professional consultants involved in a project, and it operates on a claims-made basis. So the policy has to be in place when the claim is made and not when the breach occurred. This is also required to be maintained throughout the period in which the insured can be held liable, beyond the completion date, which is 6 years if executed under hand and 12 years if under deed, subject to the maximum of 15 years, which I'll get onto later. Different forms of contract deal with the types and nature of professional indemnity insurance in different ways. NEC is much more vague, whereas JCT has 2 standard types of cover, albeit for reasons I'll come on to, these are a bit too limited. And in the example on the screen, you'll see that JCT refers to either claims or series of claims arising out of one event or in the aggregate. But what does this mean? It is important to note that aggregate policies apply against a professional's work portfolio and not just the individual project that they are employed on. This is where there is greater hesitation in using them, as the overall pot is likely to be empty when further claims arise. So looking at the examples provided, you've taken out professional indemnity insurance to the value of £5 million, and each and every policy means you're able to claim the full limit of indemnity for each and every claim made. Therefore, each claim has an insured limit of £5 million. Whereas an in the aggregate policy means that your policy for the insured period is capped at a total of £5 million. Therefore, the cost of each claim is deducted from the total limit available. So 5 million minus the value of the claim. The first 3 examples on the screen are effectively an each and every claim policy, even if the wording does not make this obvious. The next 3 are aggregate policies, and the use of the words "and in all" effectively demonstrates this. However, the last 2 may feature aggregate but actually have different overall values. So it's very important to check these. A policy subject to 2 automatic reinstatements would in effect be a £15 million policy if we're keeping with the 5 million example earlier, whereas an aggregate policy subject to unlimited reinstatements acts in a similar way to an each and every claim policy. You may ask, why have an aggregate policy subject to unlimited reinstatements? This is simply that the reinstated figure is often through a secondary insurer. So this just allows for differentiation from an insurer's perspective as to which insurer picks up which set of £5 million. The next topic that I'll be discussing with you today is consequential losses. Now, what do we mean by consequential losses? To establish an entitlement to damages arising from another party's breach of contract, a party must demonstrate that the loss sustained was, as a matter of fact, caused by the other party's breach of contract and arose naturally in the contemplation of the parties at the time the contract was entered into. It is not strictly a test of remoteness, as this applies to negligence, and these types of losses are known as direct losses. However, there are also indirect losses, sometimes known as consequential losses, which are unusual losses, where the parties could not have contemplated this at the time they entered into the contract. However, if one party is made aware of these losses, they can effectively fall into the category of a direct loss. So the first point here is consequential losses are often meant to mean indirect losses. However, arguably all losses are consequential on a breach, so it's important that your drafting is correct. And knowing this will hopefully help you recognise when a clause is unclear. The next debate is whether a loss of profit is an indirect or direct loss. Some parties believe this to be an indirect loss. However, the case of British Sugar makes it clear that it is not, and loss of profit is in fact a direct loss. It is quite obviously in the contemplation of the parties, if one party is in breach, that the other may lose profit. Where it gets tricky is the usual types of profit and whether they are direct or indirect. Let's now look at some examples where the drafting was held to be unclear. In the case of Pegler and Wang, Pegler was a supplier of taps and other plumbing supplies. Wang came along as the person to implement a new computer strategy to sort out any service issues. However, numerous delays and issues meant that the IT system was a bit of a failure. As the judge put it, Wang's performance was disastrous. And within the agreement was the clause shown on the screen that Wang sought to rely on to limit its liability for its failures. So did this mean that Wang did not have to pay for loss of profit suffered? Well, no. The court held that this clause did not exclude liability for all loss of profits, but only for loss of profits arising out of indirect or consequential loss. As I discussed earlier, true indirect losses are unusual, so the actual limitation clause was not particularly effective in limiting any realistic liability. As the claim was for direct loss of profit, the clause did not protect Wang, and if you are looking to limit your liability, you need to ensure your drafting is correct, and if you are looking to exclude loss of profits, do not tie this in with consequential loss. More recently, the court faced the question again. Here, the case concerned a distribution warehouse that was attacked by a group of young men during the 2011 riots. They started a fire by throwing 2 petrol bombs inside the building and made their escape. The warehouse burned for 10 days, causing the total destruction of the building, plant, equipment, and stock. 2 Entertainment had an agreement with Sony to look after the stock, and the sales value was approximately £40 million. The question here was, could Sony rely on the clause to exclude liability for loss of profits? Again, this time her Honourable Justice O'Farrell held that the clause should be construed narrowly, and the drafting here is muddled, and as such the loss of profit was deemed to only relate to profits associated with consequential losses. So the moral of the story here is, be careful, get your drafting right, and do consult a lawyer. The first topic that I'll be discussing with you today is limitation, and what does a limitation period mean in practice? Now, limitation as a basic principle is the period of time you have to bring a claim. This applies to court, arbitration, or adjudication, and it is it's from the date the claim is issued and not the time where someone is told to put their insurers on notice. So, for example, simple claims in contract where they're executed under hand have a limitation period of 6 years. Claim brought under deed would be 12 years. Tort, excluding personal injury and latent damage, also has a period of 6 years, and personal injury is 3 years. Where things get interesting is that negligence in respect of latent damage is 6 years under the contract, or 3 years from discovery, subject to a maximum of 15 years. Now, the Latent Damage Act was brought in following the Limitation Act. So therefore, the Limitation Act was amended using clause 14A, which stated that if the owner of a property discovers a defect, even if it's after the 6 or 12 years, as the contract execution may be, they are still able to bring a claim if they do so within 3 years of the discovery and within 3 years of the breach itself. This arose from the case of Pirelli and Oscar Faber, which concerned cracks forming in a chimney more than 6 years after the works were completed. Now, what is meant by discovery or knowledge leads to a lot of argument, but the additional stop date of 15 years will apply regardless. However, it is important to note that this only applies to designers and it does not apply to contractors, even if they're carrying out a design and build contract. There are other quirks to the normal limitation periods. For example, the proposed Building Safety Bill extends the limitation period for claims under Section 1 of the Defective Premises Act from 6 years of the cause of action to 15. Quite what this looks like, time will tell, but is likely to lead to a load of old claims being resurrected. The fourth topic I'll be talking about today is net contribution clauses. In the context of construction, if there is a defect in a scheme resulting in a loss, this is often the fault of more than one of the parties designing or constructing the project. The party suffering the loss can sue any of the parties at fault, and that party will be 100% liable for damages, if found to be liable at all, whatever their share of the blame. This is effectively the principle of joint and several liability. Now, what does a net contribution clause do? So a net contribution clause may also be known as a proportional liability clause. Such a clause is a common feature in many standard form contracts used in the construction and engineering industry, such as the appointment of an architect or an engineer. A net contribution clause states that where two or more parties involved in a construction project are each jointly and severally liable for the same loss or damage, the liability of each party will be limited to the amount which would be apportioned to that party by a court. The net contribution clause may include assumptions which will affect this apportionment. Without a net contribution clause, if an architect and a contractor are each liable to a developer for the same defective work, the developer could recover 100% of its damages from the architect, despite the joint liability on the contractor. The architect could then seek to recover a share of those damages from the contractor under the Civil Liability and Contribution Act 1978. And the effect of a net contribution clause here is that if the court found the architect only 60% liable for those damages and the contractor 40% liable, then the architect would only have to pay their proportion and the developer would therefore only recover 60% of the damages. The developer could then bring a claim against the contractor to recover the remaining 40%. With a net contribution clause, if the contractor is insolvent when the developer brings a claim, the architect, who is only 60% liable, would have to pay 100% of the damages. Therefore, this professional indemnity insurance of the architects and other professional consultants usually request that a net contribution clause is included in their collateral warranty. Until recently, such clauses were thought to be too uncertain. However, in Stephen West, even the wording as shown on the slide was held to be sufficient and therefore enforceable. Such clauses are effective and are not unreasonable for a professional to request. However, the current market is not open to net contribution clauses becoming commonplace. For example, in projects where a funder is involved, this will reduce the amount they'll be able to recover, and therefore they are unlikely to accept such a term. Now, the final topic that I'll be covering with you today is loss and expense claims. So what is a claim for head office overheads? There are various heads of claims that can be recovered in relation to a loss and expense claim. And a loss and expense claim is essentially the name given for a claim flowing from an extension of time or a disruption claim, and most commonly it is from an extension of time. A loss and expense claim is in legal terms a claim for damages and therefore is a claim based on actual cost. What we want to look at here is if the head of loss is called a loss of contribution to head office overheads. And this is not the same as a claim for overheads and profit. So what are we talking about? A contractor's overheads are commonly taken to be recovered on the income from the business as a whole, and ordinarily where completion of one contract is delayed, the contractor claims to have suffered a loss arising from the reduction of income from the job and hence the turnover of the business. But it continues to incur expenditure on overheads which it cannot materially reduce or, in respect of the site, can only reduce, if at all, to a limited extent. But for the delay, the workforce would have had the opportunity of being employed on another contract which would have had the effect of contributing to the overheads during the overrun period. So in practice, what this amounts to is if you have 5 jobs a year contributing to your overhead, if any one of these jobs is delayed, then your contribution is reduced. If the delay is caused by the employer, then the contractor should be reimbursed from this, and this is why it would be a loss of contribution to office overheads. As I said earlier, a claim for loss and expense is a damages claim, so you have to prove on the balance of probabilities that the loss has been suffered. So how do you prove it? Well, it is quite difficult, and you have to show that but for the delay, you had another job to go on to. The problem is that contractors do not tend to turn down jobs because they are delayed on another job. The case of Water Lily and McKay, here we've attached the wording that was used here. And then the reason for highlighting his wording is he was quite an interesting chap, and that's probably why the court wasn't too favourable on him. So the reason for highlighting the head of claim is that there are large parts of the industry who believe that following the case of Water Lily and McKay, that the head of loss is an automatic entitlement. However, it is very much not. Okay. So how do you measure it? Justice Aikenhead, considering these various authorities, said that the following conclusions can be drawn. A contractor can remove a head office overhead and profit lost as a result of delay on a construction project caused by factors which entitle it to loss and expense. B, it is necessary for the contractor to prove on the balance of probabilities that if the delay had not occurred, it would have secured work or projects which would have produced a return over and above costs, representing a profit and/or contribution to head office overheads. And C, the use of a formula such as Emden or Hudson is a legitimate and indeed helpful way of ascertaining on a balance of probabilities what the return can be calculated to be. The Emden and Hudson formulas are very similar. One relates to tender overheads and profit percentage, so Hudson, and the other relates to actual overheads and profit percentage, which is Emden. They both work in a similar way, effectively applying an overhead profit figure per week of delay. Neither is perfect, but they represent a rough assessment of loss contribution of overheads and profit. However, the key point here is that if you can prove any entitlement to the sum claimed in the first place, which is by far the biggest problem. I will now pass over to Ruth for our Q&A portion of today's talk.
Thank you very much, Hannah. Thank you very much, Hayley. And we've had a few questions in on the chat today, some of which Ollie and I've been tapping away answering, and some of which are still outstanding. So we've got kind of 10 minutes or so we'll rattle through some of those. Just for everyone's benefit, you will receive an email tomorrow with the recording, and we will also make the slides available on our website, and you'll be able to see the recording also on YouTube and LinkedIn. So if you haven't heard it enough once today, you can listen to your heart's content. But just quickly, I'd like to run through some of the questions that we've been asked. One of the questions is in relation to what do we mean by direct loss? I can happily cover that. What we mean by direct loss is in relation to the rules in the case of Hadley and Baxendale, which provided that there were kind of two limbs in relation to the test for kind of remoteness, damages and claims. The first limb is what we call direct loss, which are those losses which are fairly and reasonably in contemplation of the parties at the time they entered into the contract. So that would be things like claims for damages, claims for potentially loss of profit in the event they don't perform. But it's all those items that are reasonably in the contemplation of the parties. And the other limb is the indirect losses and consequential losses, which, a party would require special knowledge at the time in order for that to be applicable. So that's the difference kind of between indirect and direct. And kind of linked to that also is on the question of damages about the common law duty to mitigate. The answer to that simply is yes. Generally, a party does have a common law duty to mitigate its loss. And that when there is a breach of contract that occurs, that is not simply an open checkbook for them to do anything, no matter how mad or not, and think that they can recover all of those sums from the party that has been in breach. So just a couple of questions that I answered there. One, Hannah, I just wonder if you'll be able to answer this, because I know you've been involved in a dispute recently on this. There's been a question about LDs. Can they only be deducted once the completion certificate has been issued?
No, so the key point is it's the notice of non-completion that needs to be issued before liquidated damages can be deducted. You don't need to wait until completion of the works. You just need to make sure that the completion date as set out in the contract has passed. Issue the correct notices, so your notice of non-completion, your warning notice, your deduction notice, and your pay less notice, and then you're good to go.
Brilliant. Okay. And then one of the other questions we've been asked in relation to statutory undertakers, and whether those works which fall under an undefined provisional sum, whether the contractor would be entitled to an EOT. The simple answer is that undefined provisional sums, the contractor should be entitled to an extension of time, regardless of whether it's related to statutory undertakers. So that's the whole, that's the reasoning for undefined provisional sums. In relation to, contracts covered, for utilities works, that will all depend upon whether or not that contract is an employer's contract. And in which case, if they don't perform, then that is an employer prevention, and therefore that entitles you to an EOT. If, however, the contractor has engaged a utility company to provide some connection works, it's not technically a statutory undertaker, then the contractor will take the risk on that, and they would not be entitled to an extension of time. It would be no different to any other subcontractor that they employ. Just looking at the other questions before I move on to a couple. We were asked one, Hayley, I'm sorry to put this on you. We were asked one about the fire safety bill and whether or not that changed the limitation periods shortly. I've provided a very quick response, but if you want to add anything else to that, please do fire away now. I know that was one of the questions that we've been asked in advance of today's session. So what the impact of the fire safety bill will be.
As I mentioned in the talk, and as I can see that Ruth's answered, so it'll be 50 years 30 years retrospective, obviously, which will open quite a can of worms for all the developers and their liability. And then also they are proposing 15 years for prospective claims going forward, which would kind of bring it in line with the Latent Damage Act. So it just shows that really we have learned a lot from Grenfell, and I think it'll be quite an interesting area of construction law to look at going forward, because it's quite a big shake-up, I'd say.
Yeah, I mean, we did a talk earlier on this week to one of our clients about a developer about the fire safety bill, and the concern really is how a party's going to be able to pass that down the line. So that's just something that we discussed there. So okay. So just one question that I had in advance is in relation to clause 73.2 in relation to title to excavated material on site under an NEC contract, and in essence who has title to that excavated material. The simple answer to that is that under clause 73.2 it basically says that the contractor doesn't have title to that unless it says it in the works information, and so therefore the contractor under a contract with the employer has no obligation to move it from site, isn't able to recycle and use it for its own purposes because it's not owned by the contractor. And if the employer wants it to do something with it other than just simply excavate it, then in the ordinary course of events, that would be a compensation event. But the clue in that clause is that you need to turn to the works information and look at that in relation to those materials and see whose materials is. Because if the works information is silent, then the answers I've just given are, in my view, the right ones. So that's just one point. Just, Hannah, we were asked a question, just kind of what is the position on materials off-site in advance of this talk, and kind of how does the rules work? Can you just explain how those rules work?
Yeah, of course. So off-site materials in some ways tend to be a bit more straightforward than on-site materials. In practice, any significant off-site materials often backed off by an on-demand off-site materials bond. So what this means is that if the employer pays for any off-site materials, but then can't get hold of those materials, it can simply call on the bond. Where materials are stored off-site, there's typically a requirement for a vesting certificate to be provided, which by its terms just transfers the title to the paying party. But the issue is actually ownership with the off-site materials. It's actually tracing those materials itself. So if they go missing or they're not readily traceable or they're stored overseas, it's quite difficult for the employer to get his hands on those materials. So that's why we would recommend an on-demand off-site materials bond is put in place so they can call on that bond in those circumstances.
Okay. And I'm going to come on to a question that's been asked in the chat that kind of comes from this. But in practice, a lawyer's just making a massive big deal out of the difference between reasonable skill and care and fitness for purpose obligations in the design. Are we just basically making a meal out of nothing, or is there actually something in it?
Of course, we are not making a meal out of nothing. How dare that be suggested? It is a good point, but you can find situations where parties find themselves having an obligation that extends beyond reasonable skill and care. And the biggest problem is your insurance coverage. Your insurers will not cover you, or at least they'll try really hard not to, on the basis that you've taken on a greater liability than standard and reasonable skill and care. So even if you would have been covered but for the fitness for purpose clause, as in Hobart, the insurer will not cover you, even for the bit that you are insured. He'll just not cover you at all. So really, it's an insurance issue. And the insurers will say that you're caught by an exclusion to your policy. So that's the key point that we're trying to avoid, is the battle with the insurers if this does happen.
Okay, so I've got a view on this, but at the top of the chat, someone said that they include in their appointments some wording saying nothing in or connected with this agreement shall imply or import any form of fitness for purpose or any guarantee of life expectancy. I mean, that wording is similar, I would have said, to the wording that you had on your slide. I would probably tweak it a little bit to maybe put the words shall imply or import any liability under the terms of this appointment for any fitness for purpose or guarantee. But, you know, as a concept, the kind of quoted wording appears to be, in my view, along the right lines. I might tweak it a little bit, but the general gist of it as cited.
And I think it's really key to include that sort of wording to make sure that you're not giving anything for, say, fitness for purpose. You're not going further than what you need to.
Okay. And just briefly, I know we've kind of touched on PI a little bit. Are insurance companies, Hayley, insisting on net contribution clauses in the market? What's your kind of view on that at the moment?
Oh, well, net contribution clauses aren't kind of widely adopted, and I doubt they really ever will be, just because of obviously that restriction on what you're able to recover. But I would say that the Wren Insurance Company, which specialises in insuring for architects, they're one of the very few organisations that may require it as part of the negotiations and things like that.
Okay, and they obviously, you know, we talk a lot in the market about runoff in insurance. What does that actually mean in practice? Runoff
insurance is something that I would consider to be quite important, and it basically covers you for claims of professional negligence brought against you after your business has ceased trading, or you've retired. So if you've sold your business or closed it down as well. So it's particularly important for, as I mentioned, the retired business owners to consider, as without runoff cover in place, they will actually be personally liable and have to fund the defence out of their own pocket. So I would recommend that, definitely.
And on the subject of kind of markets, obviously, we speak to a lot of clients in relation to their struggles with the PI market. What's the general experience that we've got, would you say, in relation to PI levels in the market at the moment?
I think I'm definitely seeing more and more policies that are done on an aggregate basis, with certain areas excluded, such as cladding. That'll be a separate own aggregate. And whilst we're not placing PI insurance, we have been hearing from consultants on the other side, or clients that we're working with, that the premiums really are going up. I think there's ranging from 100 to 400%, depending on the position in the market and particular specialisms. So we're hearing that certain parties are now considering self-funding PI, or at least self-funding significant excesses. So it's quite time.
Okay, well, I think somebody's just put on the chat actually that in their opinion, the insurance market will require net contribution clause within appointments. I mean, yeah, I think it's, we all know that the PI insurance market is tightening. We all know that, the policy wording is getting stricter. We know that they are, especially in relation to a lot of main contractors and a lot of professionals, they are excluding fire safety claims. And it's not just cladding claims, it's any kind of fire safety claims. Mm-hmm. So, the suggestion that they may start, that may be a bit of a wider thing in the insurance market, may not be too far off. I'm just conscious that it's 12 o'clock or 12:01 in fact, and we promised you that we would all let you get away for 12 o'clock. So thank you ever so much for joining us today. I hope that's been of interest. Apologies if we didn't quite get to all questions. I think we got to most of them. But so thank you ever so much. As I say, the slides will be, the recording will be emailed to you tomorrow. And once you come out of this webinar today, there should be a feedback form as well. So we would greatly appreciate your feedback for today, and also obviously for future webinars as well. So thank you very much, and we look forward to seeing you soon.